A constitutional right that cannot be funded is a bankrupt promise that turns the streets of Boston into a disorganized liquidation of public safety, effectively writing off the security of the citizens to cover a management deficit at the State House.
Advocates say the SJC's decision is disappointing and they'll keep pushing lawmakers until they're fairly compensated. Now, the issue centers on bar advocates, private attorneys appointed to represent people who cannot afford a lawyer. Nearly 1 year ago, many stopped taking new cases, protesting what they say are low pay rates. The shortage led to 1,687 cases being dismissed in Suffolk and Middlesex counties as of last month. Lawyers asked the SJC to allow judges to raise pay. Today, the justices declined, saying pay decisions belong to the legislature, not the courts.
We are witnessing a systemic default on the Sixth Amendment, where the service providers of the legal system, the public defenders, have moved their labor into a permanent strike because the state's payable accounts are deep in the red. This isn't just a labor dispute. It is a total infrastructure collapse, where over 1,680 criminal cases have been written off and dismissed because the state refuses to honor its contractual obligation to provide representation. While the internal controls of the justice system are failing, the city's management is busy reallocating capital to non-citizen services, creating a material imbalance that leaves the tax-paying shareholders of Massachusetts in a state of sovereign insecurity.
I can see that if this is not addressed seriously within the next 5 to 10 years, the private bar, in terms of their ability to represent injured defendants, will crumble. It has started to crumble.
A statement from the Committee for Public Counsel Services reads in part, "We are going to continue our advocacy efforts in the State House to ensure that the private attorneys who take our cases are compensated appropriately for the hugely important work they do for our clients." Lawmakers approved a pay increase last year, but many bar advocates say it still is not enough. Reporting in the newsroom, Brittany Johnson, 5 Investigate.
I am Camilo Motado, and this is Camilo's House. As a professional focused on forensic verification, I look past the political rhetoric to see the material misstatements in the state's budget. In a standard audit, if a subsidiary claims it is too cash poor to fund its mandatory compliance requirements, but then discloses a multi-million-dollar grant expenditure for discretionary services, you immediately flag the organization for fiduciary failure. Today, we are performing a constitutional insolvency audit on Massachusetts. We are analyzing the material conflict between the state Supreme Court's refusal to adjust lawyer pay and Mayor Michelle Wu's hostile takeover of the budget to fund migrant services. This is the moment where the Bill of Rights has been devalued to a junk bond status. The operational trigger for this crisis is a functional impairment of the private bar. For the past year, bar advocates, private attorneys appointed to represent the indigent, have stopped taking new cases in Suffolk and Middlesex counties. From a forensic perspective, this is a service line shutdown. These attorneys are the external auditors of the justice system, and they have certified that the state's pay rates are non-competitive and operationally unstable. Because the state hasn't met the market rate for this human capital, 1,687 criminal cases have already been dismissed. In auditing terms, these are outstanding liabilities that the government has simply deleted from the ledger because they couldn't afford the processing fee of a defense attorney. The SJC audit opinion from the state Supreme Judicial Court has only compounded the deficit. The justices recently declined to allow judges to raise these pay rates, issuing a reporting standard that pay decisions belong exclusively to the legislature. This creates a procedural deadlock. The court is redacting its own authority to fix the constitutional breach, leaving the electorate to face the insecurity premium of thousands of accused criminals being released back into the market without a trial. As one advocate noted, if this management failure is not addressed, the private bar will crumble within the next 5 to 10 years. We are looking at a negative equity situation where the rights of the accused and the safety of the victim are both being liquidated to satisfy a legislative budget cap. But here is where the forensic trail gets volatile. While the state claims it has no liquidity for its public defense ledger, Boston Mayor Michelle Wu has just disclosed a new capital injection for immigrant services. In a move designed to challenge the federal executive, the city is setting aside millions of dollars for everything from diapers to legal services for immigrants. As a CPA, I track the traceability of funds. This is a $4.5 million private-public partnership consisting of $1.3 million in city taxpayer equity and $3.1 million from philanthropic assets like the Boston Foundation and the United Way. This reallocation of resources is a material breach of fiduciary duty. How can a city audit its way into millions for non-citizen legal defense while the citizenry is being defrauded of their Sixth Amendment rights because the public defender account is empty? This is the ultimate accountability variance. Michelle Wu is marketing this as a principle of freedom, but from a risk management perspective, she is prioritizing a non-operating liability over the primary infrastructure of the city. By purchasing second language education and legal services for new residents, while the old residents watch 1,687 criminal cases get written off due to lack of counsel, the administration has permanently impaired the social contract. The Trump administration surcharge is also a factor in this budgetary war. Mayor Wu is framing this $4.5 million as a defense fund against federal removal procedures and the withholding of federal dollars from sanctuary cities. This is a strategic risk hedge. The city is hedging against federal audits by creating its own alternative funding scaffolding. But as any forensic investigator will tell you, a drop in the bucket of $4.5 million cannot cover the deficit created by the loss of federal subsidies. This is pro forma governance, making a symbolic disclosure to satisfy a specific voting segment, while the total portfolio of the city's safety is in default. We must also audit the human impact of this Sixth Amendment liquidation. Imagine you are pulled over and wrongfully accused of a DUI because of a malfunctioning breathalyzer. You are an upstanding shareholder of the city, but you don't have the cash reserves for a private lawyer. You look to the management for your contractually guaranteed public defender, only to be told the account is overdrawn. You are released without a trial, but your professional reputation is impaired and your asset value in the job market drops. Meanwhile, the person in the country without permission is receiving a $4.5 million dividend of legal representation and social services. This is incentive misalignment at a systemic level. The final reconciliation of the Massachusetts audit reveals a management team that has defaulted on the Constitution. You have a state Supreme Court that has resigned its oversight, a legislature that has underfunded the Sixth Amendment, and a mayor who has liquidated the common fund to support a political ideology. The 1,687 dismissed cases are just the initial inventory of a safety crisis that will amortize over the next decade. When public safety is sacrificed to fund immigrant services, the yield for the taxpayer is negative. My forensic verdict is that Michelle Wu and the Massachusetts leadership are operationally insolvent. They are counting on federal cash that isn't coming and spending city equity on non-primary liabilities. The crumbling of the private bar is a leading indicator of a total systemic default. Until the internal controls of the state can guarantee the Sixth Amendment for every citizen stakeholder, any spending on immigrant diapers is a material misstatement of what it means to lead a city. I want to hear from you. Is the constitutional right to a lawyer a primary asset that should be funded first, or is Mayor Wu's Immigrant Defense Fund a necessary social investment? Does the release of 1,600 accused criminals constitute a total management failure of the Massachusetts State House? Let me know in the comments. Your perspective is the only audit that matters when the Bill of Rights and the safety of your family are sitting on the negotiation table. I am Camila Motado, and this is Camila's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.